Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Edward Elgar Publishing Limited. This book has been published by Elgar, both as a printed book, actually a hardback, and also online. It's been written by Antonios E Platsas and it's called The Harmonisation of National Legal Systems, with the subtitle Strategic Models and Factors. And we've given it a book review title, A Thoughtful Discussion on Legal Harmonisation, the Theory and the Practicality. Let's have a look at the book first. There we go. You see, as you can see, it's a high level. It's a high level book. It's a hardback there. There's the spine and then there's the back. It's not a big book, but it's as to be expected from Edward Elgar. It runs to 280 odd pages, and it's just under 300 pages. The index is quite short, but very useful. It's by page numbering. Then at the back you've got a bibliography, which again is very helpful. There's a lot of work that's gone into this book, and obviously the editor has, rather the writer has put a large amount of information in the bibliography, which is there. Then there is actually a relatively short series of conclusions. He calls a few thoughts at the back. The front of the book, there is the front page there. And then you've got the information about the online system. Then you've got the contents section, and not a large number of chapters at all, 5 in total. It's split into 2. It's the introduction into ideological nexus of the law convergence thesis, and then introduction to the factors. That's in 5 chapters, plus of course conclusions, a few thoughts, and then a bibliography. There are some tables. There is a preface at the beginning, which is quite interesting and quite detailed from the actual author. That's dated January 2017. I'm recording this at the end of the year. There's the acknowledgements section there. A lot of detail gone into this. There's quite a bit of case law that's in it as well, which is quite helpful. Then of course legislation also, and after that you get into the book itself. You can see the structure of the book. It's a book that you can read through. It's a hefty book. There's a lot of, quite a large amount of footnoting. Again, skip the footnoting and read the contents is the easiest way of dealing with it. The difficulty is that the footnoting is not as excessive as one might think, but it can put you off. And of course, this is not a book for amateurs at all. This is a book at a high academic level, and it's dealing with a very, very serious basic issue, which is harmonisation of national legal systems. It's an ideal at the end of the day in jurisprudence, which I'm sure many people will see. We tried to do it within the European Union, and we've had a lot of difficulties getting agreement because you have got different systems of law in operation throughout the planet. And that's not going to change overnight, and we wouldn't want it to, because the whole basis of law is that you have laws which are appropriate for your own culture and your own region. But at the same time, it's nice to have a bit of harmonisation, if I can put it in its most generous form. So what do we say about the book? We say this: following at least a decade of economic and political upheavals, as well as cultural shocks, particularly Brexit, is this the right time, asked the author of this book, for one to engage oneself with another legal harmonisation discussion? Well, the answer is yes, and it's a good thing that the author, Antonios Platsas, answers himself in the affirmative. Otherwise, this book would never have been written. Bit of a statement of the obvious there, but however, I think it's an interesting book because it's an important area to grapple with intellectually. I mean, we're talking here about concepts, not about the practicalities, because we're never going to get that sort of level of agreement. Let's be quite clear about that. We won't, but we can get some form of harmonisation. That's what it's about. That, of course, would have to be, again, having said, if the book hadn't been written, it would, of course, been quite unfortunate, because we would then not have had what is actually a thoughtful, articulate and carefully researched exploration of an important, understandably difficult and perplexing controversial subject. The preface alone by this well-known legal scholar is worth a read right at the beginning, because it's one or two of the opening remarks indicate revealingly that the seeds of disquiet about the European Union model and its democratic deficits were already germinating at least 10 years ago. I have to say, as a retired politician, it's a bit longer than that, but however. Now, this book has been recently published by Elgar, and the book focuses on the models and factors by which foreign harmonised legal norms are or can be transposed and implemented into the domestic legal sphere. The overall aim is, in the author's words, to bring extra-national law into the national legal order, and to, quote, open up an academic discussion of the ways and means by which theoretical models of harmonisation may or might become reality. Now, I've said before, and I'll say it again, that this is the theory. In practice, it's going to be much more difficult, but we are talking about theoretical models, and at least we're trying to embark on that course, which I think is helpful, whilst, of course, maintaining the self-determination of individual member states and organisations to determine their own destiny. That, of course, is part and parcel of it, but you can see the concepts. Now, it's interesting to note that the author's acknowledgements, the many academic contributors who have assisted the author with insights and advice are all here together. There are 44 of them from top universities worldwide: Oxford, Cambridge, LSE, Ottawa, Wellington, Florence, Potsdam, Istanbul, Delhi, Athens and Tel Aviv, to name only a few. And the author himself hails from the Higher School of Economics at the National Research University in Moscow. Now, drawing upon what is actually an impressive array of talent, of international influences and opinion, the book argues that what is termed the harmonisation thesis suggests a pragmatic rather than a dogmatic approach. The point is made that one cannot predict all potentialities through the presentation of theoretical models. Nevertheless, the author's strictly analytical stance makes this book, in our view, a valuable find for academics and those involved in the study of comparative law, especially from the theoretical viewpoint. And I would venture to suggest that it's going to be more important as the next decade comes and we enter the middle of the 21st century. This view is going to become more important, because I don't see globalization receding. So therefore things are going to have to be looked at again in a different way, because the internet has arrived big time. People are much better educated. You've seen the problems we have with Twitter and some of the social media sites, as they're called, about people putting views forward. So you can see a whole range of different things happening as the century unfolds. Now, the book is in one convenient volume, and the author has provided an amazing broad repository of references for researchers, from the extensive footnoting to the bibliography of over 30 pages. Predictably, many of those references steer readers and researchers in the direction of human rights issues, which obviously should form the core of any national legal system. That's the theory, based, of course, on the UN Declaration of Human Rights and, of course, the European Human Rights Charter. So at least you can see that that's where the beginning of it is, although, of course, the view is by some that we need to update all of this information, and that may well happen in this century. Let me conclude. It's noteworthy that the book provides ample evidence of the sheer volume of treaties, learned articles and book-length studies of human rights that continue to be published on an industrial scale worldwide. It's a pity that these are apparently ignored by dictatorships, which unfortunately outnumber democracies to which migrants in their millions, mentioned by the author, have yearned to escape. Perhaps this is as strong a case as any for the harmonisation of national legal systems, preferably in the direction of democratic values. And the publication date is cited at the autumn of 2017. Let's look at the book again quickly. There it is. It's the front, the spine and the back. Just opening it up in the middle, you can see this is a specific model of incorporating harmonised law. There we go. Just looking actually here at the UK. the ECHR, looking at Ireland and so forth. You've got paragraph numbering. All the suspects are there, all the issues are there, and I would make it compulsory reading for all politicians. It's a jolly good job we can't, of course, but it would be very helpful if people actually looked at this area and said, yeah, let's start thinking about this in a rather different way from the way we've been doing things. We can always defend our own corner, but it would be nice to have a bit of harmonisation. I think this is an excellent book for the future. It's a forerunner of a lot to come. Thank you very much to Associate Professor Platsas and to everybody involved in this publication, which I found fascinating. Good luck with all your future endeavours. Bye-bye.